including the legal fraternity as well as the IBC. So we'll dwell upon the basic principles of mediation and also how mediation is going to be a very, very big concept in the IBC. First, I just want to bring to you the participants' knowledge that as most of us know that Justice A.K. Sikri and late Arun Jaitley ji are the most prominent figures in development and promotion of mediation in India. They are the pioneers in the field of ADR. So they have been advocating for implementation of mediation in IBC also. Justice Sikri has been a strong advocate for incorporating mediation into legal system, particularly for resolving the disputes, even including the IBC. So they have been, Justice Sikri has been actively promoting the use of mediation in resolving disputes, which highlighting its potentiality of the mediation process to expedite the resolution as well as reducing the costs. And they have been pioneered and they have been instrumental in establishing a mediation as a recognized ADR mechanism. And as per the prediction of Justice Sikri, that mediation will become a dominant form of dispute resolution by 2030. Emphasizing Justice Sikri has been emphasizing its growing importance and potential. As we all know, IBB has floated a paper on this mediation and also submitted their recommendations to the board. Hopefully, once this notifies, we will see how the mediation will be implemented in the IBC. With the tighter timelines in the, without the dilution of the tighter timelines in the process. I'm sharing the PPT. Can you confirm whether the PPT is visible? Ma'am, can you confirm, Anjali ma'am, whether the PPT is visible? Can someone confirm if PPT is visible?
Yes, it is visible.
Okay, thank you. So we'll just dwell upon some of the points like brief background of IBC and the objective of the IBC and who are the key stakeholders. These are all relevant to the concept of mediation. So how the existing dispute mechanism prescribed under IBC and what is the need for mediation in IBC and what are the emerging trends and roles of the mediator, scope of mediation in IBC, what is the legal framework which is proposed. Then we'll touch upon few case studies where mediation was through the mediation mode, the cases were settled. Then what is the advantage of mediation in insolvency and what is the way forward? We'll just touch upon all these points and later we can have a Q&A session. So basically, the background of IBC, as we know, the prior to enactment of IBC, the Indian insolvency framework was fragmented and it was leading to multiple inefficiencies in delays and erosion of the asset. So to address these challenges, the Bankruptcy Law Reforms Committee chaired by Mr. Vishwanathan has shared their BLRC report, and upon the recommendations, the drafting of IBC was culminated and which was introduced in Lok Sabha, and we all know that it has come into effect from 28th May 2016. IBC has consolidated all the existing laws related to insolvency and bankruptcy as a unified framework, which has helped in streamlining the resolution process of corporate entities, partnerships, and individuals. So the objective of IBC is consolidation of all insolvency laws into a single legislation. Then again, time-bound resolution of insolvency cases to maximize the value of the assets, as well as the controlling the erosion of the value of the asset. and promoting the entrepreneurship by providing an exit mechanism for failing businesses, and enhancement of credit availability by improving the recovery rate for creditors. Like during once the CRP process resolution plan is approved, the availability of credit again becomes available to all the stakeholders, to all the companies who have good prospects in the market. There is no stagnation of the credit, so that once the eligible corporate debtor which is undergoing genuine stress and is on the verge of stress and also has good prospects, IBC gives a very good scope for revival or resolution of these companies, and balancing the interest of all stakeholders like creditors, debtors, employees, and shareholders, stakeholders. Like creditors, they can make available the credit by closing of the loans, as well as restructuring of the loans, as well as making available the credit to the prospective resolved corporate debtor. And even the debtors, uh, even the employees also, once the company revives, the employees will have a prospect. Instead of closing the company, the employees will again get back their employment, and there is no disruption in the employment process. As we are discussing about the concept of mediation, we have to understand who are the key stakeholders in the insolvency bankruptcy code. See, basically the framework involves we'll touch upon few key stakeholders like financial creditors. Financial creditors are the institutions who have extended their financial loans facilities to the corporate debtor. Then we have operational creditors who supply the goods and services to the corporate debtor. Then corporate debtors are the companies, individuals who are undergoing the insolvency process, CIRP liquidation or pre-pack, or be it may be a voluntary liquidation. Then corporate insolvency professionals. Insolvency professionals are the licensed professionals who are responsible for managing the insolvency processes under the IBC. And we have committee of creditors. Again, it's a financial creditor or maybe operational creditor. It's a group comprising of financial creditors who will evaluate and approve the resolution plans. Then we have NCLT, who is the adjudicating authority in the insolvency cases. Then we have the IBBI, who is the regulatory body who will oversee the implementation of the processes under IBC. And also IBBI is the regulator for insolvency professionals and the insolvency professionals. Sorry. Yeah. So basically, if we go to the dispute resolution mechanisms available under IBC, we know that there is a corporate insolvency resolution process, liquidation process, pre-pack process, and the CIRP process is the primary mechanism under IBC for resolving the insolvency of a corporate debtor when an application for default is initiated against the corporate debtor on non-payment of 1 crore or more. Then the process initiates once the application is submitted under section 7 or 9 or 10. So we have 3 sections where the CRP can be initiated. One is the financial creditors on the debt, there is a default, and the default on a payment of 1 crore or more to a financial creditor. And even under section 9, the application can be initiated by a service provider to the corporate debtor who has supplied either goods or services. Or if corporate debtor by itself, by passing a resolution at the shareholders meeting, deciding to initiate the CIRP process against the company by corporate debtor by suo motu, they can initiate the CIRP process. So here the resolution process which starts is a time bound and a standard duration of 180 days is provided under the act to complete this process, or it can be extended by 90 days by a NCLT order, and upon approval by the COC, the RP makes an application to NCLT for extension of 90 days. But however, seeing the track record of the companies undergoing the CRP process, further a maximum limit of 330 days were allowed for the CIRP process. Here, the IRP will be appointed to manage the corporate debtor if the debtor is to manage the corporate debtor operations. CD is a going concern. Along with that, IRP is supposed to manage the entire CRP process as per the prescribed IBC code and the CRP regulations made thereunder. Along with the other applicable regulations, the CRP process has to be carried out. Here, a moratorium is imposed under Section 14, halting all the legal proceedings against the corporate debtor. And here again, a COC is formed to monitor the entire process, and RP is supposed to convene a monthly COC meetings and place the progress before the committee of creditors. And here, as per Section 28, RP is not supposed to take up few actions where the power is vested with COC, like making changes in the management of the company or in making investments or appointment of auditor, like this. Some of the actions RP cannot take on his own, on his or her own. He has to go back to the committee of creditors. And also, if the debt size of the company is more than 100 crores, RP has to formulate a marketing strategy along with the committee of creditors to for the success of the EOI process. EOI, again, once the company gets admitted into CIRP, RP is supposed to issue expression of interest inviting the prospective resolution applicants for submission of resolution plan, wherein the plan's due diligence is done by the resolution professional, and resolution professional can take help of the professionals during this process and ensure that the plans submitted are within the Section 29A compliance. And then he or she has to share the resolution plans. He has to put up to the COC for their commercial wisdom. They have to see the feasibility and viability of the plan. The committee of creditors votes on the plan, and within all this process has to take up within the timelines prescribed as discussed above. And the company then, if the resolution is approved by the COC, the RP makes an application to NCLT for approval of the plan. And once the plan is approved, then the plan will go for implementation, where a monitoring agent is appointed who is an insolvency professional. And if the resolution plan is not approved, COC rejects the resolution plan, then company goes for liquidation. Then we have the one more dispute mechanism under resolution mechanism under IBC, that is liquidation. If the during the CRP process, if there is no resolution plan or the resolution plan is rejected by the COC, the corporate debtor will be recommended for liquidation. Even in under Section 33, there are certain conditions where NCLT can directly pass a liquidation order of a CD. Here, liquidator is appointed who will ensure that the CD is sold as a going concern, or there may be there is a sale through the e-auction where a prescribed process is the online platform is provided, and the IBP has given guidelines in this regard, where the assets of the corporate debtor are liquidated and distributed to the creditors in the ratio of as per the section 53 waterfall mechanism. And in case if the company is a going concern, the company will continue. Otherwise, the company will be dissolved upon completion of asset distribution. So we'll again discuss one more dispute resolution mechanism, which is a non-starter under IBC, that is pre-packed insolvency resolution process. Few companies are resolved under pre-pack insolvency process. This is introduced in 2021 for MSMEs. The following are the features where the debtor with the corporate debtor with the consent of unrelated financial creditors with a voting of 66%, they can initiate this pre-pack insolvency process, where a base resolution plan will be submitted by the corporate debtor for COC's consideration. And here, for swift resolution, 120 days is prescribed. Then again, it can be extended another 60 days. Here, the pre-pack combines the benefits of informal workouts. That is, before the process starts, the negotiations, or you can call one mediation, where the corporate debtor proposes to the financial creditors a base plan based on which the entire process kicks in here. Here, this process has some kind of features of informal workouts, and the formal insolvency proceedings will initiate. So before formal process starts, there is an informal majority of the work is done prior the insolvency process. So under this existing mechanism under IBC, NCLT plays the key role. They act as the adjudicating authority for these process. They oversee the initiation of CIRP and the whatever the issues that come during the CIRP. NCLT is the adjudicating authority, and in the liquidation process also, NCLT ensures that the compliance of the code is maintained in spirit and law. And on the NCLT orders, we have appellate authority, NCLAT, which is an appellate authority where the decisions of the NCLT are challenged and appealed against. So before we go to the dispute, what is exactly the concept of mediation? So I just want to make few statements here that the Justice Sikri and also many pioneers who have been advocating for mediation, they see mediation as a game changer in insolvency, especially particularly in streamlining the process and reducing the litigations. And here, mediation is a concept where we have collaborative solutions. See, the issue or the dispute, whatever it may be, it will be taken through a fostering collaborative approach. So even if mediation fails, the parties will be with a different mindset. So I'll just explain few concepts how the mediation works. Mediation once the parties have referred to mediation, it is shifting from an alternative to primary method for dispute resolution. See, basically mediation is referred so that an alternative or some method is evolved for dispute resolution. And also mediation offers long-term cost-effective solutions for building and better relationships and faster and more effective way. Legal dispute resolution, somewhere we have the adversarial systems where it's time taking, cost, all these can be avoided. So insolvency proceedings are many a times complex, although they are not adversarial disputes that may arise between creditors and debtors and also other stakeholders. The delays are high in insolvency proceedings because of the litigation, where mediation can offer a viable alternative to traditional litigation. It also provides more efficient, less costly, and flexible method. Mediation is not a very rigid method for resolving disputes like other ADRs, arbitration or conciliation. Mediation is a very flexible method where it fosters the consensual resolutions which can help in preserving the business viabilities. And mediation allows tailored solutions that can meet specific needs of the parties involved. Sometimes all disputes are not taken up by, which are taken up by the courts. The process followed and the method applied and also the regulations, the whatever the court proceedings follow, some disputes may be resolved through some consensus where there may be some tailored solutions. There, mediation works and addresses the specific needs of the parties involved. And mediation will help in advancing the goal of the code, IBC code, for maximizing the value of the debtors by timely resolution and avoiding the disputes within the timelines. So mediation, as per the framework proposed, as per the paper submitted, mediation is a process which is in some in UK, US, it was in some of the countries it is mandatory, but however it is proposed as voluntary in our recommendation, in the IBBI recommendation to the IBBI recommends mediation as a voluntary mechanism in the IBC. So here, if we look upon what is the need for mediation in IBC, as we all know, we are practicing into NCLT and we see how IBC has been progressed so well till now. But however, there are some hurdles because of which the IBC is not able to meet some of the expectations when it was promulgated. So some of the, since IBC is more close to 8 to 9 years, we are the IBC is in the market. Now the some of the issues which are identified for slow progress in IBC is because of the overburdened tribunals. As we all know, the NCLT and NCLATs are experiencing significant case backlogs, and there are delays in insolvency resolutions also because frivolous litigations are filed and moonlight cases are filed where there are no real issues. So these all will be weeded out when mediation is integrated into the IBC, and which can elevate the burden of NCLT and NCLATs by resolving the disputes outside the courts, that is through formal with adjudication processes. So when the moonlight cases are filed or when frivolous litigations are filed, at the initiation, at the filing of the cases where the tribunals can refer them to the mediation, lot of time can be saved and the tribunals will be free to take up the cases of approval of resolution plan and liquidation or pre-pack, which will help in again pursuing the objects of the IBC, that is quicker resolution and maximizing the value of the assets. Again, it is high pendency and delays. Despite time-bound resolutions, many cases, as we all know, the minimum time taken is exceeding more than 330 days. And many cases we have seen it has exceeded 700 days. So the time-bound resolution is not happening because of the litigations and procedural complexities. As many times IBBI has intervened and they have seen how the procedural complexities have been evolved, and many times IBBI has um, pitched in and at regular intervals they have been amending the regulations so that suitably some complexities are addressed. So here again, mediation will act as a faster alternative for settlements. Then preserving business value. So once the applications are filed, section 7, 9, then the insolvency process starts. Adjudication is happening at a slow pace, for which the value of the business is getting eroded. In many cases, it was noted that once the application is filed and till the time it gets admitted, the majority of the assets value is getting eroded in the corporate debtors. Hence, when the cases are referred to mediation, it enables the quicker resolution, or in case if there is a settlement, then the value is preserved, then the corporate debtor can continue. And even if CD is a going concern, the operational viability of businesses can be retained. Then when it is a mediation process, here the principles of mediation and how the mediation approach, the parties always come to a consensus through a collaborative solutions. Here, unlike courts where the court decides and the parties have to agree to the dispute settlement, the mediation is a process where both the parties come to some collaborative solution, where both the parties will be at a win-win solution, where the parties mindset changes, that the parties will come to some consensus where the mutually beneficial agreements are found. This approach not only resolves the dispute, but amicably. The dispute may be settled by court order, but when it comes to mediation, there is a lot of process where mediators follow, where parties are made to sit across the tables and discuss the issue. It's not the mediators are trained in such a way that at the table the parties are only discussing the issue, that is the dispute. Hence, when there is a settlement agreement, the parties will be at a mindset that it's a mutual decision, not court decision which is binding on one party. Hence, when it comes to section 9 or section 7, the business relationship between the promoters and the stakeholders are cordially maintained when the application or the dispute is referred to the mediation process. So we just touched upon basic concepts of IBC and the stakeholders involved, and what is the exactly the benefits of referring to mediation under IBC. Now we'll come to the concept of mediation. We'll discuss few concepts like mediation is a structured, voluntary and confidential process. So I wanted to stress upon here, when the mediation is referred for a dispute, the mediator will follow a structured process and the process is voluntary. See, when it comes to court, there are certain, there are rules where it is bounded, and we are supposed to follow the exactly what is mentioned under the prescribed regulations and mandates as per the rules made therein. But however, mediation is a voluntary process and it is structured, but however, the mediators can always discuss the issue based on the discussions between the parties and try to bring to some consensus. Again, mediator will not impose or give any kind of suggestions how to reach to a settlement. It is only mediator will act as a facilitator, and it's a confidential process. See, when a mediation agreement when suppose NCLT refers a section 9 application to a mediation, then the mediator is appointed. The mediator will start the process and will maintain confidentiality of the entire process. Mediator is not supposed to disclose the information, data, or issues. When one party makes some information, then mediator is not supposed to disclose to the other party. So it's a confidential process. And even when a mediation order, if mediation agreement is reached between the parties, then the agreement is reached. When the mediation settlement or agreement does not happen, mediator is supposed to write in his order, mediation failed. Only that much he has to write. The mediator is not supposed to write anything apart from that. He is not supposed to bring what was the discussion, what was the issue, what has happened, nothing. It's only mediation failed, and again go back to the respective court for continuing the dispute process. So here mediator is a neutral third party who will assist disputing parties in resolving the conflicts. It's only through negotiation techniques where mediator will sit with both the parties and facilitates the negotiation. So unlike litigation or arbitration, mediation does not involve a binding decision. Instead, the parties retain control. So one more important point I want to mention here is, unlike in courts, the decision is with the court. But however, in the mediation, the parties retain the control on the outcome. That means when a settlement is reached, it is again, the settlement is because of the parties' discussion or deliberations, parties coming to some consensus and settling the dispute. Or if they does not come to any settlement, they do not reach to any settlement, then the mediation fails and the process is again get back to the court. So here, mediation under IBC, there are two methods. One is preventive method, the other one is proactive method. So preventive is that can help avoid conflicts to the extent possible. So when all disputes cannot be prevented, mediation, when suppose when a dispute is, when a case is filed for a dispute, then when the dispute is referred to the mediation, once the process is completed, the mindset of the party changes. Hence, for the Section 9 applications or Section 7, the business or the dealings, commercial dealings of the parties, between the parties, the mindset changes so that the parties will identify what is a potential area of contention. That means what is a potential dispute, so that the parties will come to some structured agreements between the parties, or otherwise they will come back with a disagreement. So here in IBC, we can have a proactive mediation strategies which will help the parties build stronger relationship, reducing the risk. here the framework has to be evolved for resolving the disputes. So some of the emerging trends in shaping the future of dispute resolution are deal mediation, and we have the review existing contracts or agreements mechanism, neutral observers in the meetings, early warning mechanism, advocacy and awareness program. So here deal mediation is a structured mediation where a certain deal, the mediators are appointed and it will be reached. Then reviewing existing contracts or agreements. In case if there are any disputes which are supposed to, any service terms which has to be provided, and regularly reviewing these contractual terms, like suppose supply of goods or supply of services, if there is a dispute in the um, uh, service providing or otherwise goods providing, when there is a breach of contracts or the agreements. So regularly having a review of these contracts on the service or the whatever company is handling with the creditors, this will this process also will help in reducing the disputes. Then neutral observers in the meetings. Here it is proposed that in during the CRP process or during the SCC meetings, this is one of the best practices some of the insolvency professionals are practicing. They will appoint one of their support team member or another insolvency professional who will be appointed as a neutral observer in the COC meetings or SCC meetings, where they will give a review or opinion whether the things are going progressing properly or there any issues which are going to come up, and what are the observations of this neutral observer. So basically I want to bring notice to the participants in one of the big resolution process case where I have handled. I had a neutral observer who was an insolvency professional who was also part of our support team or legal, they were supporting us. I always had a neutral observer in the meetings or in the process where they used to advise me, where they used to advise for any future litigations which are going to come up or when to file the cases. Like in we had the CD had a lot of lease agreements with the go downs. The CD was into scanning business, and CD was into tin Aadhaar based, and also SEBI KRA. They were intermediaries, so lot of documentation has to be maintained with the go downs, and the go down owner was supposed to file cases against us. Before that, we the observer, whatever agendas I used to place and discuss, the observer used to come back to me and give suggestions. Can we go for this point to NCLT and seek directions? In one of our CDs lease premises also, we had some furniture where the government was the leasehold owner, and we had the properties, some of our furniture in that company, in the premises of government building. And the government, the state government wanted to us to remove all the furnitures from that building. But however, as a proactive measure, we went to NCLT and sought directions that the property cannot be removed. Once the property is removed, we will not get any value. It was more than 1 crore value. And if we sold in the market, we would have got not more than 10 lakhs. So we went to NCLT and we took orders to the, we took orders to the government, state government, that government can use the whatever furniture fittings belonging to CD, and the government supposed to pay us lease. So like this, observers keep giving us strategic help or support or direction, avoiding future litigations or complexities in the process. they are also some kind of mediators who can help us in the process. Then early warning mechanism, this through the risk management of the CD, they can, the committees, whatever the internal committees or the external committees, the companies or the corporates have, they can give us the early warning mechanism so that any future litigations can be avoided. Then the advocacy and awareness, as majority of the legal fraternity or the judges, pioneers like A.K. Sikri has been pioneering the mediation as the best process, where not only the issue but also the relationships beyond the issue can be maintained. So since the CD is in the society and the CD has to deal with lot of stakeholders like debtors, creditors. So once there are disputes and the disputes are referred to mediation, the mediation where the consensus agreement comes, the parties are always at the good relation, because it's not settled through a court process or a litigation. It is through mutual mediation process they have arrived at a settlement. So all these benefits of mediation, the advocates or the advocacy profession or the stakeholders, institutions, they are bringing lot of awareness programs on the benefits of mediation in the IBC or whatever whatever other mechanisms, other courts. So recently I have attended one of the refresher course on mediation by Missing Bridge and the ICM, both of them together, they have arranged a mediation refresher course. So there's a lot of awareness which has to be spread from the institutions or the professionals on the explaining the benefits of mediation to the stakeholders. So as we were discussing on the emerging trends and also the mediation features, the basic feature is it's a voluntary participation. Here in mediation, all parties choose to engage in the process through voluntary. They are aware that it's a voluntary process, not a mandatory one, like a court process. And the basic feature is voluntary confidentiality. So the discussions and disclosures, whatever happens during the mediations, are private and they are cannot be used in court of proceedings as an evidence. And even if one party makes disclosure to the other party certain things during mediation, it cannot be used against the as a evidence against them. And it's a non-binding, since it's a mutual agreement, it has to be formalized. Mediator, whatever suggests, are not binding on the parties. And it's a neutral facilitation process where through a dialogue, the parties come to some consensus or disagreement. And it's a collaborative approach. So what is the role of mediator? So mediator's primary role is facilitating communication between the parties so that some voluntary agreement is reached. He has to facilitate a dialogue. See, basically when both the parties are at dispute, they will not come to a consensus when the mediation process is referred to. When the mediation process starts, it's a role of mediator to make an opening statement of the issue and bring some facilitative dialogues between the parties. And he has to ensure that the parties always are at dialogues with respectful communication. Here, mediator has to make it very clear that no derogatory statements or any disrespectful words are used in the mediation. This point has to be clarified clearly to the parties. And the process, the mediation process is a structured process where ground rules are set and a conducive and productive environment is created between the parties. and mediator assets only in negotiation. He only explores the options. See, basically, once they sit across the table, they are supposed to sit with a respectful with a respectful mindset between both the parties. They are not supposed to use any kind of derogatory language. They are supposed to sit only for exploring any options for negotiating the terms without imposing solutions. Say, suppose both the parties will have some solution. Party A has some solution to the issue. Party B has a different solution. Then parties cannot impose, mediator cannot impose the solutions between the parties. It is only workable solutions after sitting. Mediation is a process where both the parties sit across the table. Then again, they have a private discussion where each party is made to sit separately with the mediator and explore options. Sitting individually, parties sit separately. It's a private discussions where one party will explore the options and negotiate the terms. The other party will also give their options and also negotiate the whatever the terms for settlement. Then again, a joint session is held between the parties after the private discussion. A joint session will be organized, and where again the mediator has to maintain neutrality. He has to be unbiased without providing any legal advice or any imposing his decision making. Whatever explored solution between the parties, both of them has to finalize and come back to the mediator on the settlement. So we have touched upon basically how mediation process works and how the mediator has to ensure what are the key features. As we all know, the the regulation 12A of commercial codes, before any commercial dispute, the adjudication process commences. First, it is mandatory to refer to mediation within the prescribed timelines. There are prescribed timelines within which once the application is filed under commercial courts for a commercial dispute, the parties have to mandatorily go for under regulation 12A, not under IBC, it's under commercial courts. They have to go for a mediation for settling the dispute in the first instance. But however, in IBC, it's not mandatory. Whatever is proposed is not mandatory. It's a voluntary. So what is the scope of mediation under IBC? So when we come to the processes, we have pre-admission stage, post-admission stage, and implementation stage. So when it comes to scope of mediation under IBC, under pre-admission stage of insolvency applications, when there is a dispute between the operational creditor and the corporate debtor, under an application under Section 9 will be initiated. Here, operational creditor will initiate the process. Sometimes, many of the times, the Section 9 applications filed, there are real issues, or sometimes there are moonlight kind of issues where the issues will be settled even before the adjudication process. So here the disputes are settled before admission itself, like where once the issues are settled, majority of the applications which are filed under Section 9 are to threaten the corporate debtor. So the parties will be interested to settle before the admission stage itself. So once it is here, before admission, if the AA refers the matter to the mediation, then the burden of NCLTs will reduce. Here, the IBBA has proposed a mediation mechanism to facilitate early resolution between OCs and corporate debtor. so that the business relationships are preserved between the corporate debtor and the operational creditors. As you know, as you all know by now, that mediation is a voluntary process and settlement of dispute process by consensus of both the parties by a settlement agreement. So IBBA has recommended a mediation mechanism for Section 9 applications. And one more, then comes the post-admission stage. So post-admission stage, as we all know that once the process starts, there is a mechanism of Section 12A withdrawal application by 90% of the committee of creditors agreeing for there are two stages. Once the application is admitted into CARP process, before constitution of COC and post constitution of COC. So before constitution of COC, it's almost like a settlement process where the applicant will reach a settlement with the creditor. The applicant creditor will reach an agreement with the corporate debtor for settlement with the settlement terms, and where the dispute is settled only between the parties. Here, the settlement is happening only between the parties. Then we have post constitution of COC. So post constitution of COC withdrawal also is a settlement, but with the approval of 90% of the voting by the committee of creditors. So again here committee of creditors is constituted. Committee of creditors will consist of again financial creditors or operational creditors, or with both. So with the 90% of the COC approval, the process will be withdrawn. That means again the corporate debtor has to settle with the members of the committee. Again, what happens here? Bilateral or multilateral parties are involved here. When a settlement happens, it may be a bilateral. After the COC is constituted, it will be a bilateral, and where a lot of parties are involved, again it is a multilateral, which is again in a phased manner. Then we have one more scope of including the mediation in avoidance transactions. Here, avoidance transactions are certain dealings by corporate debtor where the interest of creditors is set aside and the transaction happens. Transactions which are like preferential nature, preference is given over one creditor over the other. Then transactions are done with the parties at a undervalued transaction, like which is less than the market value. Then fraudulent transactions, as we know, these are all PUFE transactions under section 45 to 66. Fraudulent transactions are intended to defraud the creditors with an intention of fraud. Extortionate is unfair lending agreements or exorbitant terms are charged. So here, what's the scope of mediation is, once the transactions are identified and avoidance transactions application is filed, the beneficiary, whoever it may be, the creditor or the financial creditors, they can have a mediation process to come to some agreement for settlement of the whatever recovery happens to the corporate debtor or the creditors. They can have a mediation with the persons whom against these transactions are filed. Then one more scope is cross-border insolvency. Here, the adoption of unilateral model law. Singapore is the pioneer, and Singapore is the International Court of Mediation Center, where India is also a party there. Here, in cross-border insolvency matters of foreign insolvency proceedings, a cooperation between the Indian and foreign courts. Although this is not yet enacted, this is a significant where process, cross-border process where the CD has a foreign assets and liabilities, a mediation process can help in settling the cross-border insolvency issues across various foreign jurisdictions. So some of the, again, we have informal restructuring efforts. So before initiating any formal insolvency proceedings, companies can engage into informal restructuring to address the financial distress, like negotiated settlements can happen between the parties and agreements with creditors like OTS. The debt can be restructured. This is again an informal mediation kind of efforts. Then we have the we have already discussed the pre-pack insolvency, where the majority of the work is done before start of the process.
Ma'am, I had a question here. Can I ask the question, ma'am?
Yes, sir. Yes, please.
So, ma'am, you said that NCLT can also ask for a mediation to be done.
Yes, sir.
So
Yes.
this would be mostly in pre-insolvency stage, or it can be at any of the stages. Means what is the general practice? That was the first question. And the second thing is, the second question was for mediation. Say I am an insolvency professional. Is any additional qualification required to act as a mediator?
Okay, sir, I'll answer two of your queries. One is the mediation happens even prior to NCLT. When the application is filed prior to NCLT, parties by themselves, suo moto, they will go for mediation, sir.
So that is voluntary, ma'am. I'm talking about.
That is voluntary. Even in court referred process also, NCLT in some of the cases they have referred for mediation. In next few slides we will discuss, sir.
Okay.
NCLT, where it feels there can be a negotiated or settlement which can be reached between the parties, they will facilitate for a mediation process.
Understood. Okay.
Yeah. Then coming to becoming a mediator, so the qualifications and the process of becoming a mediator is yet to be notified. As of now, we have court-referred mediation and voluntary mediation. So there are some associations like we have International Arbitration Center at Hyderabad, Karnataka State Mediators. So we have some councils state-wise and also central, where the empaneled mediators can be referred to the dispute. They can be, based on their expertise, the disputes can be referred to that empaneled mediators. And some, usually in February or March, there will be notification from MCA for empaneling the mediators. So if you have that prescribed eligibility, you can apply through that, and then the respective courts, wherever you are applying for that, you will be empaneled in that mediation, like how we have IP empanelment, like that some empanelment will happen. It will be state-wise again. So you will be, when the court wants to appoint a mediator, from that empanelment list, they will appoint.
And ma'am, what about the fee? The fee will be determined on a mutual agreement basis, or is there any guidelines regarding the fee of the mediator?
Sir, fee of mediator is again decided between the parties voluntarily. But when it is court-referred mediation, court annexed, we call it as court annexed mediation. That means the court is referring to mediation. Court annexed mediation, the court will decide the fees, sir. It will be per sitting or on the whole as a consolidated on reaching a settlement, or on the disagreement, mediation fail, anything for the process, court annexed, court will decide. And if it is between the parties have to voluntarily decide on the mediator fees.
Thank you.
Okay, welcome, sir. So mediation is also proposed to be included in the IBC framework. So what are the basic recommendations of the committee? I'll discuss going forward. So IBC currently, we do not have any formal statutory framework for mediation. So since the tribunals are overburdened, mediation is gaining a track as an effective ADR mechanism. And the mediation bill in 2021 and the code of conduct for insolvency professionals getting regularly updated, which is giving a hint that the government is trying to integrate mediation with insolvency. So pre-admission mediation has been suggested for operational disputes and also for early stage efforts. So already we discussed in pre-admission stage, settling of the disputes before initiating the process, mediation can be initiated. And even during the CRP, as you all know, there will be a lot of disputes between the creditors, COC and the resolution applicants, or for the claims. So all this can be settled through a mediator. As we all know that for the once the resolution plan is approved by COC and once it is filed with the NCLT, in between there are a lot of disputes which are referred by the RAs and also by COC. Lot of cases are filed. So to have a smoother process and ensure that not a lot of time is wasted in the litigation, the mediation can be a great tool even during the CRP process. The issues or the whatever disputes can be mediated. And whenever there is a distribution issue or settlement of claims, there are disputes, all this can be effectively referred to the mediator. So I'll just have some water. Give me 2 minutes. So this is a for the benefit of the participants, I just put the mediation process flow, how the mediation process happens. One, there are two processes. There are two methods of mediation. One is court annexed mediation, where mandatorily court refers for mediation. The other one is voluntary. Voluntarily, the parties decides go for a mediation on the dispute. So once the mediation process is initiated, here again, it is again can be voluntary or tribunal directed. That is tribunal annexed, they call. A neutral third party, often an insolvency professional or a trained mediator, is appointed in the I'm specifically discussing on the specific to IBC. So a neutral party who is an insolvency professional or a trained mediator who is empaneled with the councils or with the going forward with the NCLT also, they'll have a panel of mediators. Then a pre-mediation conference is held where mediator calls for both the parties and outlines all the rules, scope and confidentiality of the terms, which he'll explain all the mediation rules, like it is a voluntary, parties are not supposed to use any derogatory language, it's a mutual process, mediator is only a facilitator, and he will make an opening statement. Making an opening statement to both the parties is one of the toughest skill of the mediator. So when I was attending the course, I felt before joining the course, I felt mediation job is little easy. But when all the principles, how the sessions, private session, joint session, then again making opening statement and what are the strategies to be followed to bring for an attempt. It's only an attempt by mediator. Mediator is nowhere responsible. Even if mediation fails, mediator is not blamed for that because mediator is only working as a facilitator. So small rules, outlining the rules, how mediation happens, then mediation sessions are held. Each party will be allowed to present their views. Then mediator only facilitate the negotiations. He will not give any solution. So as a mediator, you are not supposed to give any solution to the issue. Although you know it will be the best solution for both the parties, you are not supposed to give any opinion or solution. Because ultimately mediation is a process where parties have to feel that they only arrived at a consensus settlement process. So once both the parties private sessions are held, then again a joint session is held where they'll explore all the possibilities and negotiation or settlements, whatever it may be. If they agree, that is fine. Settlement agreement is written and both the parties will sign and the mediator also will sign and stamp and submit to the court if it is a court annexed, or otherwise the parties will be bound to, if it is a voluntary mediation, the settlement agreement, both the parties are bound to implement the terms therein. So once the mediation is reached, the order can be filed with the NCLT and through an NCLT order, it will be enforceable. So when we discuss about the framework, we can also discuss about the advantages. So as we all know, mediation will bring in most cost effective solution for the dispute and time efficient also. Like court, once your case is posted today, maybe it will be posted after sometimes vacation and sometimes there are holidays or court is overburdened, so they'll give you a long date. So time consuming litigation can be avoided. And when mediation is referred, the business value is preserved and the relationship between the parties also. When the mediation process happens, the mindset of the parties are in such a way tuned that they themselves maximum try to reach a settlement so that they can avoid relationships. Sometimes, most of the times, since CD always deals with the creditors, be it operational creditor or financial creditor, at the end of it, not only monetary, but there are relationships which are beyond these commercial contracts. So when it is referred to mediation, parties will try to when it is a court process, they will not, they will only follow the process and they will only discuss the dispute and what are their legal issues. But when it comes to mediation, the more their relationships are also come to discussion because it's a private discussion. It's not open court where parties will be reluctant to come back and share some good relationship what they had between the CD and the other creditors also. And as we know, it's a flexible and confidential process. It reduces the most of the backlogs with the NCLT. So currently there is no legal recognition as no explicit provisions are incorporated into the IBC or regulations because the paper recommendations are submitted and it is yet to be notified. So here dispute resolution currently we have only through NCLT which can be referred to adjudication, mediation. In Vidarbha Industries versus Axis Bank, Supreme Court has emphasized on the settlements through mediation before admission. So we'll discuss on the, we'll go to case laws in the last.
Can
So
I have a
we'll-
question, please?
Yes, sir.
See,
Yes, please.
yeah, so what happens when, settled, a mediation which results in a settlement and it is filed with NCLT is not eventually, the terms are not met by either party, it fails.
Hmm.
What is the net result then? Does any of the law prescribe, or are they intending to prescribe that then it can be admitted into IBC?
Yes,
Into
sir.
CIRP? Because currently, you see, many rulings are coming that a settlement process, if it is not fulfilled, is neither a debt under Section 9 nor under Section 7.
Hmm.
So what will happen if the mediation process fails?
Sir, once the mediation process fails, then again the parties dispute continues in the with the adjudicating authority under IBC.
Yeah, but then you see the rulings that are coming say that it is neither a financial debt nor an operational debt. So under what section do you file the CIRP? I mean, that's the current scenario. Obviously, if they come up with mediation, they will have to provide a solution to this.
Yes, yes, sir. So we will just we can maybe your issue will be discussed in the whatever the committee expert committee has summarized. I'll discuss few summary points where expert committee has recommended for the mediation in insolvency.
Right. Okay, thank you.
Yeah, we can discuss this once we complete this whatever summary they have recommended.
Okay.
So after the mediation bill 2021, an expert committee was constituted by IBBA in March 23 and they have submitted a report in January 24, sir, for perusal of the policy makers, so that their recommendations or observations can be used as a mediation principles in insolvency system. Even prior to initiation of insolvency or during the CRP process and even during the implementation of the plan. See, the recommendation was the mediation framework under the code should be self-contained with an independent infrastructure to ensure code's objectives are met. So they want us independent infrastructure which has to be set up like at NCLT, which should be a self-contained infrastructure which should ensure that the stricter timelines of the objectives of the code in the timelines prescribed in the code are not deviated. Since the IBC applications are rights in rem and public interest are involved, there is a strong case for exemption from mediation via an amendment. That means they want this as a voluntary, not mandatory. Since rights in rem is involved, they want this to be voluntary, sir, not a mandatory one. Here, the committee has recommended a phased introduction as a dispute mechanism. They are proposing for phased manner, not in a complete notifying the complete recommendations. This again they want to see as a flexible process where allowing implementation learnings like in a phased manner. If it is implemented, whatever may be the drawbacks can be again codified. Then again, mediation as an ADR method only with the prescribed existing statutory timelines only, whatever are the CRP timelines. They want to include the mediation along with within that timelines and delegating the powers to implement mediation to central government, that is IBBI. Then again, establish an in-house mediation secretariat at NCLT. Like how we have registry at NCLT, they want a separate mediation secretariat at NCLT. And the timelines prescribed 120 days the timelines also they have specified for the mediation, when the mediation should complete. Then again, granting power to extend the timelines is not provided to NCLT, or granting any interim relief during the mediation also is not allowed. NCLT is not supposed to extend any timelines for closing the mediation. Within that stricter timelines, it has to be closed, and no interim relief can be granted during this mediation process. And ensuring the recognition to these mediated settlement agreements. And also during this mediation, how the moratorium, what is the scope and what is the kicking of the moratorium, these provisions also were recommended. Then IBB regulations will be modified suitably for specifying the procedures for conduct of mediations, like including automatic termination where timeline expires. Not unlike CIRP, where we can go for extension of timelines and automatically go for liquidation. This mediation they are proposing with a stricter timelines, otherwise mediation automatically terminates. Then appointment and removal of mediators, how mediators can be appointed, and what are the functions of secretariat at NCLT. Then how capacity building programs has to be for the mediators. Like I had an early query. Here, after the new notification, we may have guidelines. What is the qualification of mediator under IBC? And what are the capacity building programs, like how we have 60 hours mandatory training programs, all this. And how the enforcement of mediated settlement agreements. As we were discussing right from beginning, the committee has recommended the mediation as a voluntary by consensus between the parties. And here, voluntary mediation is post institution of the Section 9 application in OC matter. Here, while filing the application under Section 9, there is no, in the application, there is no process to file separately for the mediation process. So going forward, there'll be a separate process for mediation in the application when Section 9 or 7 application is filed. The provisions or the process for mediation also will be included in the stages. And post institution, they can also go for intercreditor issues or claim issues. So once the CRP process starts, when the claim is submitted or COC is constituted, even during the process, any disputes, how these issues has to be settled, this is also provided. Then competent authority is again here NCLT or by parties by mutual consensus. References here, the pre-institution stage, it can be referred to mediation. So post commencement, so post institution, but pre-commencement mediation can be made with to NCLT. The mediator mandates automatically at the commencement or 30 days from referral, whichever is earlier. So once CRP process post pre-admission into a process, the mediator will be given a mandate, and within the timelines, the mediation has to close, or otherwise automatically the mediation process closes and the application will go for mediation. And one more is, I want to correct. One is, once the CRP order is made, a 30 days window will be given where the mediator will be appointed, and if there is any possibility of settlement during this period, that can be entered and mediation settlement agreement can be reached, and again it will go back to NCLT and the mediation settlement terms will continue. Within 30 days, if there is no mediation, automatically the admission process, CRP process starts. The CRP commencement date starts from there. Then post commencement, mandate of mediator ends, then 12A remains unaffected. The 12A thing continues, but once during this post commencement of the process, there are two types of approvals they are proposing. One is 66%, the other one is again that 90% settlement process. Then again, if there are any disputes during plan implementation, during process, we have already discussed how the appointment of mediator for overseeing the process, or how during the process any disputes come, how the mediator can be appointed. Then again, once the plan is approved during implementation phase also, mediator will be appointed, but again, the reference will be as per the IBC code and also as per the approved plan terms. Then insolvency processes identified by the committee are CARP. And here the financial creditors is not identified by the committee because they want to implement in a phased manner. Initially, they identified for any mediation process for operational creditors or any application by the corporate debtor. And pre-packed insolvency, fast-tracked, and even PG matter, even the individual insolvency scope of mediation is identified in the expert committee. Then whatever processes identified, the CRP claims, collation, and even intercreditor issues, there could be disputes between the COC members themselves. So even these issues can be referred to mediation. Then whichever applications under section 65 are filed under adjudicatory powers of the NCLT, these are also can be referred for mediation. Individual insolvency, avoidance actions. So avoidance also here, no fraud allegations involved. Once if it is a fraudulent transaction, it cannot be referred for mediation. Then what operational infrastructure here, as in previous slides we were discussing, an independent court annexed secretariat mediation cell will be appointed to oversee and manage the mediation under the code. And staff, systems, personnel, specifically mediation process, the entire regulations will be notified once the mediation IBC, this mediation code gets notified. And even for the professionals also who will be appointed as a mediator. Then again, one important aspect is use of online e-meetings, e-filings, online paperless mediation, AI tools are recommended so that it can facilitate for ease and time, so that it's a time can be saved, time efficient. Then enforcement of mediated settlement agreements. As we all know, India is being a pioneer in the mediation. We know the background of mediation, the panchayats. We had an excellent system of panchayats. India should have been a front runner in the mediation, but however, we are lacking. We are lacking at the implementation of mediation in the global. Although we are ranking, our rank has come down in ease of doing business, but when it comes to the commercial contracts execution, India is not, India is at the one of the least in the commercial contracts execution. The commercial contracts execution is not at ease. So once this mediation is notified and is getting implemented in future in going forward, then the commercial contracts execution becomes is then India will be pioneered in the mediation process. The basically in mediation we have bilateral disputes and multilateral disputes. The layer of disputes, bilateral disputes becomes little easy for getting a mediation. When it comes for multilateral disputes, then again a separate skill is required by mediator for handling the mediation with multilateral dispute parties. So for enforcement of mediated settlement agreement, parties have to approach AA or appellate authority for enforcement without filing separate legal proceedings. So within that case only you can file for implementation of the settlement agreement. It's like similar to Rule 8 of AA rules, which deals with the withdrawal process. So at post-admission stage, process disputes can be settled under Section 12A of the codes. They are granted statutory sanctity by being recorded in the NCLT order. In case, sir, here I'll answer to your point. Sir had a query. In case there is a breach of settlement terms, the aggrieved party may seek revival of CRP through NCLT.
Right, thank you, yeah.
Yes, sir. So again, when it comes to the cost of mediation has to be borne equally by the parties unless mutually agreed otherwise. Mediation costs during CRP are excluded from insolvency resolution process cost. Here, the committee has recommended bifurcation between mediation cost and the CRP cost. So then provisions are also introduced for reimbursement of mediation expenses at NCLT or NCLAT or Supreme Court. Since the IBC, they have seen how IPs are struggling for the CRP costs. So they have a recommendation on the reimbursement of mediation expenses. So here, sir was asking, we had a query on the mediators. So a proposed pool of mediators will include some retired members of NCLT or NCLAT or senior advocates with 10 successful insolvency cases who have handled, or ex-senior officials from IBBA or banks or financial institutions, or we have insolvency professionals with 10 years of experience. This is what is recommended by the committee. But again, it is left whether the recommendations will be considered when the act will be notified. When there is a mediation going on during the CRP process, then the process and timelines will run parallelly. There is no additional time which will be allowed. Just give me 2 minutes. I'll just have some. Sorry, actually in Hyderabad, it's very hot, sir, humid. So I'm having water in between. Excuse me for that. The mediator's mandate will automatically terminate up within 30 days on the reference or upon admission by CIRP, whichever is earlier. So this is 30 days timeline is given to the mediator. Once again, just bring to the notice of the participants the advantages of mediation in insolvencies, speedy resolution rather than traditional litigation timelines, cost effective, preserves business relationship, litigation burden reduces, and more important, it's a flexible and party driven. Here, no adjudicating authority or the arbitrator or the mediator gives any solution or order. It is a creative way where mutually agreeable solution comes. So as of now, the challenges and limitations are, till now the Mediation Act is not notified. The IBC currently does not have any formal mechanism for mediation, and there is no legal mandate or structured process for the mediated settlements in the insolvency proceedings. So there is a gap for pre-admission dispute resolutions and negotiations during the CRP process. And one more important is, there is a limited awareness and acceptance of the mediation till now. So once maybe the act is notified, then there'll be a awareness and the acceptance of the mediation settlements. And there is some uncertainty on the legal enforceability of the mediated settlements in the IBC. And there is in the IBC, there is a power imbalance. Creditors are often at hold greater leverage, discouraging cooperative settlements by the debtors. As we all know, there is a settled principle that it is the commercial wisdom of COC. So the commercial wisdom of COC is the highest principle in the IBC. So it gives a greater leverage for the creditors rather than the debtor for reaching a settlement. So as we were discussing the global perspective, UK encourages mediation in ADR. Singapore is the pioneer, and there are judicial insolvency networks guidelines which are very clear, and the mediation agreements are implemented. And in US, the mediation is the commonly used negotiation for reorganizing the commercial disputes or resolving the disputes with the creditors under court supervision. This is again court annexed. So India can adopt the international practices to develop a structured mediation in insolvency ecosystem. This is a brief discussion on the concept of mediation, IBC, and what are the expert committee recommendations. We'll just touch upon few case laws. So Reliance Infrastructure Limited and CLE Private Limited. Here the petitioner was Reliance Infrastructure Limited. They are into an EPC and infrastructure company, and respondent is a CLE Private Limited. Here there is a long-standing financial and commercial dispute involving claims and counterclaims over assets and monetary dues. And there was a disagreement on 6,503 crores. And the legal proceedings has been under litigation before referring to the mediation under Bombay High Court. It's a court annexed to mediation. This was resolved under Mediation Act via the Bombay High Court Mediation Center. What are the settlement terms? The asset transfer. The CLE Private Limited to transfer 5,777 crore worth of assets and economic interest to Reliance Infrastructure through loan conversion. A decreed amount of 726 crores loan was restructured. And also the settlement agreement had legal safeguards like warranties and indemnities in favor of Reliance Infra. Here, both the parties had lots of rounds of joint discussions, private discussions. Then again, the dispute was discussed, and there was a settlement which was declared as full and final, which also extinguished all pending claims and disputes. All previous pending claims and disputes also extinguished like a clean slate. And also there was a settlement that there should not be any shareholding related party ties between the two companies. And there are no changes to the shareholding, directorship or capital structure. Usually in some time in resolution plan, the shareholding rights, directorship or the capital structure changes. But here in this settlement, there was no change in the directorship or capital structure. So by way of settling the dispute between these two parties through mediation, the Reliance Infrastructure Limited asset base and their potential strengths of potential financial and operational strength or position is being not disturbed by an amicable mediation. And these through Bombay High Court, the NCLT has referred to Bombay High Court, and this settlement has been reached between the parties. The company was under, there was an application filed under Section 7 in this case, Reliance Infrastructure Limited. Here in Reliance Infrastructure, we had a bilateral dispute. When we come to multi-party dispute, we have a case of Reliance Communication between versus State Bank of India. This is a multi-party mediation. The Reliance Communication involved numerous creditors like financial institutions, operational creditors, government agencies. So under the supervision of NCLT, the parties were engaged in mediation sessions. Some skilled mediator was appointed. There were some complex disagreements that has arisen during this process, and there were collaborative discussions between the creditors on a debt. On the restructuring of the debt, the consensus was reached by debt reduction, asset sale, and equity infusion. So the mediation agreement reached by way of consensus on the debt restructuring. And this case is a classic example how facilitating communication between the parties for a compromise among the diverse stakeholders and without competing, without disputing on the rights of the parties, without compromising or their interests, potentially through a compromise or communication, the interests of parties have been protected, which has led to more efficient and mutually acceptable outcome without going for adverse long litigation process. And here one of the case where we have multi-party mediation, but however the mediation was reached, but after the mediation agreement is entered, there were challenges and the mediation, formalized mediation also failed. So this is a case where Mr. Parvinder Singh versus Intech Capital Limited, the potential limitations in current insolvency. This is because of the current insolvency framework. Once the mediation scope in IBC is notified, maybe this will ensure that there is a legality to the mediation agreements. So following successful mediation facilitation, Mr. Justice A.K. Sikri has facilitated mediation in this case. The NCLT judgment admitting CIRP being set aside initially. However, complications arose when financial creditor approached the NCLT, resulting in reactivation of CIRP. So initially, the multi-parties have reached an agreement. There were no clear provisions for integrating mediated settlement into insolvency process. There was an uncertainty. So the failure of, in this case, highlights that there should be need for more robust mechanism to incorporate mediation outcomes to formalize into the insolvency proceedings, especially when the multiple creditors with divergent interests are involved. We have one more case law, that is Sunil Kumar Dahiya versus Union of India. Here we bring a critical challenge where multi-party mediation, the enforceability of the agreements when not all parties remain committed to the mediated outcome. In this case, settlement was reached, but again, 80% of the creditors' consensus has been reached. The settlement was later challenged by one creditor who has initially triggered the CRP. So here the mediation was facilitated and mediation was reached, and again the person who has initiated the CIRP has again challenged and went again for triggering the CIRP. So there should be a formal legal recognition within the IBC framework for mediation settled agreements. So in this case, although the agreement was reached, the corporate debtor has faced multiple challenges for implementing the binding of the mediation agreements, since there were no specific provisions for binding of the settlement agreements. So we have one more case law, that is PK Oberoi versus Vigneshwara Develop Well Private Limited. The resolution of the challenges faced here came through a connected matter through Delhi High Court. In this case, we have the Delhi High Court, which upheld a scheme arrived by the parties on a mediation. Parties have reached to a mediation and Delhi High Court has upheld this scheme. Here, the judicial recognition provided the necessary legal backing to enforce the mediated agreement. So, in our earlier case, there was no judicial recognition to the mediation agreement. Here, the Delhi High Court backing judicial recognition, the mediation agreements was implemented. So, however, it is significant to note in this case, it was not directly to IBC provisions. So when we notice in this PK Oberoi case, the mediation agreement was implemented because judicial recognition was there by Delhi High Court. So there should be a recognition to the mediation settlement agreements in the IBC provisions itself. So currently there is a gap in IBC framework regarding the formal recognition and enforcement of mediated settlements. So way forward. So to recognize the mediation settlement as a mediation settlement agreements into the IBC for effective dispute resolution, explicit mediation provisions should be provided in the IBC framework, and we should have mediation centers, expert mediation centers, specialized for mediation, and also which should be linked to NCLT or NCLATs, and the experts who are mediators should be trained properly, and the framework should be properly laid down in the IBC framework. And the commercial mediator should be trained, and the secretariat or the mediation centers or councils should have a skilled pool of professionals for insolvency related mediation. The subject matter experts or the mediation process experts should be trained properly, regularly, and they should be the panel should be prepared properly by way of a framework. And the institutions who are into the mediation, the framework, the regulation should encourage and promote the pre-insolvency mediation for the voluntary resolution. As by now we have been discussing the scope of mediation in IBC and what are the benefits, what are the perspectives of mediation into the IBC and what are the challenges, limitations. As we see, mediation is a complementary tool, efficient and flexible, which helps in mutual consensus dispute resolution in the IBC. And mediation is a great tool which supports IBC objects. It greatly aligns with the goals of the IBC for value maximization and revival of the distressed entities. And it is a multi-door dispute resolution, alternative dispute resolution, which gives a balanced approach for settling the dispute through mediation. So the current position is the committee has recommended various whatever the framework for the including in the IBC for the successful mediation tool into the IBC, which will help IBC progress in a better structured way so that the timelines, time consumed by the time taken for settling the disputes and also time lost to the NCLTs can be properly addressed through mediation mechanism. And mediation is going to be a very big mechanism by year 2030. These are the closing remarks from me. And now the floor is open for any questions, thoughts, or reflections on the discussions. Any questions or any thoughts or any clarifications regarding the topic which we have discussed?
I have a thought or maybe a clarification.
Okay.
Am I audible? Am I audible?
You are audible, sir. Yes.
Now, I think mediation is going to be mandated before an OC goes in for a CIRP process. Am I correct? It's going to become mandatory, isn't it?
For
I mean,
that,
that is the thought.
yes, for that 30 days, sir. Pre-admission and commencement of CRP process 30 days. Yes.
Okay. Now, and they are mandating that it has to be under the supervision of a mediator.
Mediation is done by a mediator. Yes.
Yeah. So now that they are kind of imposing a cost on the company because a mediator will come at a cost.
Huh.
A cost is being imposed on the company. Even if I do not want to go for mediation, maybe I do not think that mediation will help. Maybe I've already explored mediation independently on my own. Yet I'm being asked to go through a formal mediation process and bear the cost. Do you think, how far do you think is this justified?
Sir, since it is again not voluntary, it's a court annexed mediation. Sir, once the act gets notified through IBC, then we will be knowing how this cost will be paid.
I'm sure the cost will have to be borne by the parties to the mediation.
It has to be borne by parties, yes.
So what I'm saying is that, you see, normally when an operational creditor comes into the CIB process, he's already explored a lot of options, including, mediation independently with the counterparty. Now, again, advising him to go mandatorily really go through a mediation process by involving a formal mediator, incurring further cost. I do not think that that is a very justified thing. That's an opinion, of course. and people may differ, but I think that you see, this imposing a mandatory mediation is not a correct way to go about it. It should be voluntary.
So pre-admission, it is a voluntary process. Then for that 30 days period, it is a mediator appointed for 30. They have to try the mediation process for 30 days. Then again, if it fails on the 30th day, it is automatically admitted into CIRP.
Okay. I get your point, though I still feel that, you know, this 30-day mediation is mandated by the court is also a bit harsh on the parties, I believe.
So these are
Anyway,
only
that's my
recommended.
opinion. Yeah, these are recommendations. And of course, when the law comes, it will be the law. But I
Correct.
believe that, you know, this is a bit harsh on the parties.
Yeah, it's only recommendatory. Maybe once the code is notified, we will come to know.
Ma'am, I have a query here. So,
Yes, sir.
so the person who will be the interim resolution professional,
Hmm.
will the same person be chosen as a mediator, or it can be a different person, or it will definitely be a different person? So that was the question.
Yes. Yes. Yes, sir.
So it will be a different person, you mean to say?
Yes, sir. It will be different person.
Okay. And ma'am, have you come across instances where, you know, like this is from your experience, where such mediation has actually been able to resolve some of the complex matters?
Yes, sir. Yes, sir. Even I'll not name the company. One of the big listed company of Hyderabad, there was an operational creditor dispute which was filed in the Section 9 application. And successfully through mediation, there was a settlement in the NCLT. There could be lot of cases, sir, and there are a lot of cases which are settled in under Section 9. It's a successful process under Section 9, where the usually operational creditor Section 9 application is filed as a threaten the corporate debtor. So usually once the CD comes for some settlement terms, it will be a mutual settlement through mediation.
Madam, I believe that a settlement pursuant to a Section 9 application is always because the CD is scared that he will lose his company. It is not because, you see, in a mediation, what is essentially happening? The mediator is only guiding them. He is not suggesting anything.
Correct.
There
Correct.
is no carrot, there is no stick.
Yes.
In a Section 7 application, there's a stick that if you do not settle, then you lose control of your company. So people have come forward and settled.
Even Section
Mediation, that kind of a scare is not there for the parties. So they will, you see, supposing I owe money to somebody, until and unless I fear losing something, why will I go and settle with him? And the parties have already explored these avenues, and then they have come into IBC. So
Correct.
putting an additional 1 month for mediation, I really feel that, you know, this may be a non-starter.
30 days period is also a very short period for commercial
I agree with you.
disputes.
Yeah.
Commercial disputes, but however, it is a recommendatory in nature. As of now, we can have some thoughts on this.
Yeah, I agree.
Any more thoughts, sir, from the participants? They can share their insights. We all can learn together. Maybe Mamta ma'am is also there. Mamta Binani ma'am. Yeah. So any more questions, sir? Any more thoughts? Okay. Anjali ma'am, I have completed my presentation and we had Q&A session also.
Shall we conclude, ma'am?
Yes, yes, ma'am. Completed and we had a Q&A session also.
Thank you very much, ma'am, for taking out time and addressing session on the topic mediation under IBC. Thank you very much for sharing your valuable inputs on the topic. Thank you very much.
Yeah, I thank all the participants and thank you ICSI IIP for giving me this opportunity and thank you all for patient listening.
Thank you,
Thank you very
Suhasini ji.
much.
Thank
Thank
you.
you.
Thank you.
Thank you, Swati.
Thank you.
Thank you.
Thank you.